Hey, Brian Parker here again. Another exciting adventure of Law and Lawyers Unplugged. Today we're going to do another SoloSuit review. I do this every once in a while because that's really my my job, is to look out for people that are facing, frankly, in my opinion, predatory practices. That's, as a consumer protection attorney, I'm always on the alert for that. So people bring me a fact scenario and I say, oh, you're the victim of this. And for 30 years, that's how you analyze things, and you hopefully get better as you get older. And my brain has gotten better. It's a little slower, but I get to an even better educated place once I think things out. And that long-winded explanation is my attempt to tell you I found more videos from SoloSuit offering themselves as this alternative that just surprised me. This is still out there and people use this service. My opinion, again, the whole thing is my opinion, but I'm going to back it up. Unlike SoloSuit, that offers at one point to tell you that they can save you thousands of dollars by doing this one approach later on in the video, which is not the way to go. It's like they live in bizarro world. Like, here's what you're supposed to do, and here's the opposite of what you're supposed to do. It's bizarro world. Anyway, what's bizarre is the first video. And so what I'm going to do is I'm going to take a look at some of their videos and tell you why you should stay away from this, and how it's a lot like when I tell you in my lawsuit defense videos to use the other side's paperwork. So I'm going to use SoloSuit's own documents and videos to show you how incompetent, in my opinion, they are. So this first video is George Simons, who's at it again, a co-founder of SoloSuit, telling you here's how his company handles Cavalry SPV1 LLC. Here, take a look at this snippet. If you looked at the video, it's 0.18 to 1 minute. Just take a quick look.
These guys are one of the biggest debt collectors in the U.S., one of the biggest debt agencies in the U.S. You know you've been sued by them if you receive a complaint document that looks like this. All right, so if you get a complaint document, if a process server gives it to you or hands it to like a family member or nails it to your door or something like that, and it has Cavalry's name on it and it has your name on it, then you know you're being sued by them. All right, and you gotta take it freaking seriously. All right, don't just go to sleep and like forget about it. You gotta take this seriously, or else you will lose your case, and then you're gonna have to pay even more money. All right, that's bad news.
Now, he's telling you how to handle a Cavalry video lawsuit, and he's the service to come to. But look at the document he's got on the screen. It's a Midland Credit lawsuit complaint that he's covered up the name and put Cavalry SVPV over the name, the Midland name. You're going to trust your lawsuit to this guy that's literally covering stuff up? However, one line down, now remember, he's created this video. It's his video. He can put whatever he wants. It actually says Midland Credit Management. He forgot to white out or cover up. So he took a Midland Credit lawsuit, told you it was a Cavalry lawsuit, and that he's fully familiar how to get you out of this. Look out. It's his own video. Now go to a Midland video from SoloSuit. I'll give you a couple of seconds to look at that. Shazam.
All right, first, you know you've been sued by Midland Funding if you receive a document that looks like this. All right, so if you get a complaint document that has Midland Funding's name on it and your name on it, then that means you're being sued for debt. All right?
Okay, so 0.28 to 0.40, he tells you if you're being sued by Midland Credit Funding or whoever it is, it's actually Midland Credit Management. Midland Funding is sort of the purchasing arm and has taken a backseat in a lot of states, and I sue in a number of them, or have sued in a number of them. It's Midland Credit Management. He seems to focus on Midland Funding lawsuit, and I wish he had, because if you look in this video, his video, and his document, it's a Calvary SPVI LLC lawsuit, not a Midland. He created this video and put his own schlocky attempt to tell you how a pro he is. Remember, I say pro, and look for my fun pro tips from him. So that's what you're getting when you go to SoloSuit. That's the owner, George Simons, who can't even create his own video that he's completely controlling and puts up the wrong documents as though you can't see the difference. You're going to see when you watch their videos, it's very condescending, some of the things they show you, and I'm going to show you that too. So on this Calvary video, which is a Midland Funding, and a Midland Funding, which is a Calvary, maybe they need a bottle of whiteout, I don't know. So they tell you, hey, there's only 3 ways to handle a lawsuit, and that's 1, write an answer. I'm calling BS on that. It's not. An answer is 50% of the way if you want to save yourself. In states that have account stated complaints, and in fact, if you look at that video where he got the wrong companies, it says account stated. You have to have a counter affidavit. He doesn't advise you that. That's a major thing not to tell someone about, because at least in Michigan and a couple of other states, if you fail to do the counter affidavit in a certain amount of days, you automatically lose your case. It's the only issue then is how much do you owe, and that's case law, and that's the account stated statute. See all my videos on killer affidavits and how to do the ASS account stated affidavit. I've done plenty to protect you. Don't follow this advice. Number 2, he says, write your affirmative defenses. You only get 1 chance to do this or you lose it. BS on that. You're probably hearing a buzzer going off because you get more than 1 chance. The rules allow you to amend. Amended pleadings are, they go backwards, meaning let's say you do an answer and then it comes out there's information you forgot or you found new information. You have a right in most states to amend your answer or your lawsuit within a certain amount of days, but after those certain amount of days you have to ask the court's permission. But you got this nice window, you go, oops, I made a mistake, you can amend, and then you get to add more affirmative defenses. So, and that's the same on the other side too. If they do amendments, you get a right to amend. So you can jockey with certain rights to amend that he says you don't have. Bring it or lose it, which is not true. So I'm calling BS on that. And then number 3, and he says this in all his videos, make 2 copies. Call him BS on that. For your safety, make 4 copies. You need 3, make an extra one. And what he doesn't tell you, there's finite nuances, small things that save your butt and turn out to be really good that you did that. And one thing is, go to the court with 3 copies. And here's the key. Here's the real pro tip. Hand in a bunch of copies for the court to timestamp them. And they will do this. They got a machine. You just go boom, boom, boom. It's very easy. Great advice. So no one can ever accuse you of not timely filing with the court, because that comes up. Oh shoot, did I make the 21 days? It's for your own personal nervousness, and also when they accuse you of not getting the answer in time. Here's the court stamp. It's a nice little nuance that will not be seen in any of these crappy videos. SoloSuit videos. Hopefully mine aren't. But he recommends you go through SoloSuit, of course, spend the money, and let them do the walking for you. And as my video progresses, look how he talks down to people as far as going to the post office and things like that. He then has a video on doing validation letters, and there's so much there. I'm like, oh shoot, I'm going to go back to doing hour-long videos again. So I'll just hit the highlight. He advises people to write a letter telling the debt collector to sue them. At 9:45 to 10:17 of that video, and we'll put up the link for the video. I'll even show you. Here you go. Shazam what he says.
If you validate the debt, then cease contacting me for any other reason other than to tell me that you're suing. All right, that's one of my favorite ones, honestly. So it's like a cease and desist clause that's covered early on in the sections of the FDCPA, where even if they do validate the debt, you can still send them a cease and desist. Okay, it's a pretty good move. And people use that pretty good, right? Where you play that card, and then maybe they do sue you. If the debt isn't a very large value, they probably just drop it and forget about it. But if they do sue you, then you can just go over to SoloSuit and you can use their answer document to respond to the lawsuit and then win your case.
You never invite somebody to sue you. Why do you poke the bear? Why take a punch at someone? What do you think is going to come back? Now, the analogy isn't strong that telling someone to sue you means they're going to immediately sue you, but why be antagonistic if there's an ability there to work stuff out? Validation is for both parties. You say, this is not my debt. You send off that validation letter, and maybe it comes out, you go, oh, that's that debt. And I have that happen with a lot of clients. We all have busy lives and memory issues. Or you can see it clearly isn't yours, but don't be telling people to sue you, because they will. That's another thing he says. If you do certain things, they get scared of you. I'd like you to think about that for a second. How many debt collectors are scared of you? Now, they're scared of me, but I'm a weird guy, jerky guy, and it isn't fear of me. I'm 162 pounds, 5'8". But I have this brain where I read all the laws and I stick to them and I know them, and that's what's scary, is following the law, all right? So that's what scares them. Telling them to sue you is an interesting way to go, but you can see George is saying that's his favorite pro tip. I wonder why. Oh, wait a minute. He sells a service where he sells you answers, and he'll serve the answer for you, and not once will he timestamp it. He'll just mail it, and we'll get into the priority mail. He talks about cease and desist. Cease and desist letters, and I've done a video on them. I'm not charging you. You can go to my video. I think it's dispute letters, validation letters, and cease and desist letters. And there's tons of copies you can take for free off my website, collectionstopper.com. And cease and desist, it says 15 USC 1692 CC. And that talks about who may communicate with you if you get an attorney representation or you send a cease and desist letter. And there's 3 ways they're allowed to contact you, even when you send a cease and desist letter. I'll just read them. They're telling you they're not going to bother you anymore. That's an interesting approach. Number 2, they can say, we're going to invoke specific remedies. They're either saying they're going to sue you, or they're going to look further into the collection, or they're allowed to contact you and say, again, they intend to invoke specific remedies in a different way. That's sort of the same thing. Where applicable. Oh, some states you're not allowed to follow up with a call. So it depends on the state, but it's a federal act, so it supersedes any state acts. The point I'm trying to make is George says they're not allowed to contact you once you send them a cease and desist letter. And there's only one reason, and there's more than one reason that they legally are allowed to contact you, and by mail. So they just can't collect on you. That's what a cease and desist is. It's cease and desist collecting. It's the actual title of that subsection of the act says cease communication, but it's really about ceasing collection. So following George's advice to tell people, go ahead and sue me, could get you sued. 1023-1053, you can watch.
Then here we go. Finally, last point that you probably want to put into your debt validation letter is you can close by threatening legal action. That's one of my favorites, right? Americans are litigious for good reason, because that's how we make people play fair in America. You can say, hey, debt collector, if you don't do this stuff, I'm going to sue you. Okay, if you keep on contacting me, I'm going to sue you for harassment. Also, if you don't provide validation of the debt, that's a violation of the FDCPA. So I'm going to sue you for $1,000 for that. And then if you didn't provide validation within the 5 days, I'm going to sue you for that too. You could be just making all kinds of money.
And it tells, again, how he wants the debt collector to sue you. He also says at 1045, if they don't validate the debt then you have a right to sue them for $1,000.
Also, if you don't provide validation of the debt, that's a violation of the FDCPA. So I'm going to sue you for $1,000 for that.
Totally wrong. Now hear me out. They must provide you with your validation rights, 1692G(a), and then if you send out a validation response, they're not allowed to collect upon you. They must cease and desist, 1692G(b). But they also can exercise the right of not validating the debt, and as long as they don't collect upon you or communicate with you, then there is no way you can sue them. So you ask for validation, you got the Dunning letter, you ask for validation, they don't respond. I see this, it happens 30% of the time. Before a client hires me, I'll give them some stuff to do, so maybe they don't need to hire me. And a lot of times I don't hear from that client again, or they'll call me and go, hey, they haven't got back to me. Well, if they don't get back to you, you don't have a right to sue them. You only have a right to sue them if they don't get back to you and then continue the communication with the collection attempts. That's how you get to sue them. He also says in his video at 10:40, you can really make some money with this harassment violation and this contact when you said cease and desist. He gives you all these examples how you make $1,000.
If you don't do this stuff, I'm going to sue you. Okay, if you keep on contacting me, I'm going to sue you for harassment. Also, if you don't provide validation of the debt, that's a violation of the FDCPA. So I'm going to sue you for $1,000 for that. And then if you didn't provide validation within the 5 days, I'm going to sue you for that too. You could be just making all kinds of money. But in a lot of cases, you want to threaten legal action because that lets them know that you're serious.
I don't believe this guy's an attorney. I looked up the state bar in Utah. Nothing, crickets. His advice, and there's other videos I'm going to show you, they're just left field, man. He should not be given legal advice or business advice, because I'm going to tell you about that too. You only get $1,000 in a FDCPA lawsuit. So when you sue them, they can violate the thing 10 ways to Sunday. You only get $1,000. That's a statutory violation. Now, if you can show, for example, 1692E, you're not allowed to contact someone at work if they tell you, once they tell you, stop contacting me at work, I can't take personal calls, and they continue and you lose your job. But let's say you're making $800 a week and you go 10 weeks without getting a job because of their calling all the time. That's actual damages that you can show. So you're entitled to what's called an actual damages. That's more than $1,000, but it's not $1,000 for every violation. If George knew his own job, the FDCPA is the basis of everything that SoloSuit does, and he does not know it. SoloSuit does not appear to know the law that regulates what they do for a living. Kind of interesting. He's selling answers and service tools, and that's why he's telling you to put the letter in the letter. Go ahead and sue me. Make my day. Remember that expression, the Clint Eastwood, go ahead, make my day. Well, guess who benefits if you're using him and you get sued? You're going to use his package. Is that cynical? Is that American? Is that corporate philosophy? Why else is he giving advice like that will just get you sued? So I'm going to give you the condescension alert. Condescension alert. Listen how George explains the second part of his video. So in the video of how to write a validation letter, he says, here's how to write a letter. And by the way, if you went to Podcast Plus at Collection Stopper, I've got every letter you want to everybody, and I'm not charging you. If you want to use it, fine. If you don't, fine. I'm not going to, it's all pretty much self-explanatory. You're an adult. I'm not going to talk down to you. But he says, part 2, we'll do the mailing of the letter for you. Of course, they're going to charge. Here's why. Because he says the post office is a horrible place. It's just, you got to buy a printer and you got to get printer ink. And why just give it to us? It's really condescending. I'll let you watch it. Look at 11:12 to 11:54 in the validation letter video, Shazam.
Step 2, mail the letter. Step 2 is simple but complicated. It seems pretty simple, you know, mailing the letter. I did that. I had a pen pal in the 4th grade. I mailed stuff. How hard is it, right? Well, this is like legal documents. A lot more is on the line. You want to make sure you don't mess up, right? So first, in order to mail it, you gotta have a printer. Right, you gotta have a printer that works and has toner and ink and all that stuff's ready to go, right? Or you gotta have access to it. Maybe your friend has a printer, maybe the library has a printer. But you gotta get these documents printed. Then you have to know how to use the post office. The post office is a pretty crazy place. Honestly, whenever I go to the post office and I'm in line, I'm always like freaking out. I'm like, man, feels like the world's ending. Feels like dystopia in here, just a little bit. Never a pleasant experience at the post office.
So he's telling 500,000 employees of the U.S. Post Office that they have a crappy place to work at, and it's a nightmare in there. It may well be not the fastest place, but it's not as he describes it in a way to trump up his or buttress his come and use us with the wrong advice that'll get you sued and you got to go through him. He offers this pro tip in that same validation video about mailing, and I call it, it's not George's pro tip, it's a dope giving a tip. At 11:53 he says you should use priority mail, but he also talked about in other videos in this one how serious the validation letter is and how it has legal consequences. Yet, and he also said they're like legal documents, there's a lot more on the line. Yet he tells you to do a half-assed job with these legal documents. And his pro tip, but I say it's just a big dope giving a bad tip. He says do priority mail, don't do certified mail, because you have to go fill out a form and stand in line, and it's like the end of the world when you go to the post office. And here's his big wrong advice for you. It's more about anything he tells you about court. My advice, don't listen to him, because this guy's not been in court, you can tell. And if he has it, I hope he wasn't representing anybody but himself. So the court rules specify certain ways you must serve somebody. You're allowed to send a lawsuit non-personal, meaning instead of in person. In some states, if you do it a certain way, and it's called certified return receipt requested. In Michigan, for example, personal service, which is here you go, buddy, and sending it by mail, certified return receipt requested, are equal. The Supreme Court makes all those rules, and it does not say one is better than the other. George says, just send it priority mail, it'll stand up in court.
A little pro tip here on mailing out the document. We've found that the best way to mail the document is actually to use priority mail. A lot of people say use certified mail, like request the return receipt, signature request, all that jazz. We find the best way to do it is this priority mail. You can get the tracking number with priority mail. It stands up in court and it shows proof that it was delivered, just like anything else, right? You don't have to pay the extra like $5 or whatever for the return receipt.
It literally won't. There are Supreme Court rules that are made that said you must use certified return receipt requested. So he's giving you advice where a person receiving your mail can receive it and go, didn't receive it, and they would be legally correct, certainly if it's a lawsuit. So this pro tip, he's saying you'll save money if you just don't go to the post office, which, by the way, you have to go to the post office to either get the priority envelope or to give the priority envelope. He's claiming priority mail is better than certified mail. And that's his pro tip. Use priority mail instead of certified mail. Well, if pro means problem or proctologist or profitable, then I guess to George that is pro. But if you use George's advice, you will have a problem. It will be profitable for him because you'll buy his services, but using his service, in my opinion, will feel like a trip to the proctologist. I hope I got that joke. Because my point is, keep a paper trail, register by mail. You send priority mail, all you get is evidence it was delivered. But the court rules, you're going to be in court, require you have Bob Smith signed off. So even the court rules talk about who can sign. An attorney can sign. A corporate representative can sign. But that corporate representative better have her name on it. The attorney better be representing the person, and legally he can or she can accept. Priority mail doesn't allow any of those specifics, which the law requires. But if you want to accept legal advice from this pro, then go for it. And I got to get into this video. We did a video about George's and SoloSuit's motion to arbitrate, and the basis of that thing was you go and you get sued. If you really want to make the debt collectors shake in their boots, do a motion for arbitration. So use our service to answer and do affirmative defenses the wrong way we tell you to do them, or at least not enough, and then do a motion to arbitrate. And what happens is, this is what he says. You know what? 2.09 of his video that I'll put up on there. Boom.
All right. So step 4 would be to move for arbitration. Okay? What that means is you can just throw a big wrench in the debt collector's machine in the lawsuit. You really throw them off guard by moving for arbitration. All right, so what the heck is that? What is arbitration? Arbitration is really just the simpler, so what is that? What is arbitration? Arbitration is just the simpler alternative to trial court. All right, the debt collectors are suing you in regular trial court, and they do that so they can use the rules of civil procedure against you. They want to make it as difficult as possible for you to represent yourself to get access to justice in the court. So arbitration is just a simpler alternative to court.
He's telling you, move for arbitration at 2.26, and he says, quote, it's a simple alternative to trial court. A, no it's not. B, your whole business is selling legal documents that you can't use in arbitration. Why are you telling your customers to do something that's going to kick them out of spending more money at your business? This guy, he's certainly not an attorney, but I don't know about being a businessman. But then I thought about it. He has you do the answer and whatever else you pay him to do, and they'll do all the service for you, and it appears they do it wrongly. They don't keep the proper... If they're sending all this stuff prior to mail, you may have some real problems about service. I would, if you're going to hire this service, make sure they say they're going to send it certified. They'll go, yeah, but it'll cost you $5 more. Yeah, but it'll be done right. You could save your ass and not be responsible. Well, you wouldn't go to SoloSuit if you're looking to save your ass. See my part of my video on proctologists. He claims that alternatively, arbitration is a simpler way to get your case resolved. It is not, because none of the rules of procedure or rules of evidence apply to an arbitration setting. It could be the person ruling on your case is not an attorney, sort of like George. It would be like George. Go through his videos and then go, do I want that guy arbitrating my case? I'd like to win. So it's not a simple alternative. In fact, he's telling you to avoid court and court rules when you go through arbitration. That you have a legal right to arbitration. No, you do not. You have a contractual right that one or the other party will exercise, but it's not an amendment in the Constitution or a seventh or a sixth or any other right. The right to arbitrate. It is codified in the law how it's done. Contractually, you have to end up there. In fact, court rules mention arbitration, and I bring that boringly up because you don't need to file an answer through George. Some states allow you, and probably all of them. I practice in a couple of them. You can file immediately a motion to dismiss if you truly want to go to arbitration, just on arbitration. And the court rules say, if you win that, and by the way, courts want to go arbitration, they want this stuff off their docket. They got a huge docket, and the legislature's breathing down their necks, really, to get stuff done in a certain amount of time. And if they can get rid of that case, they'll get rid of it. So if you file a motion for summary disposition and don't answer the lawsuit, you have that right before you answer. That's considered, in most states, a response, a legal response and you're not going to get defaulted because you're telling the court, we shouldn't be spending any more of the court's time or our own or the other parties. This belongs in arbitration. Here's the arbitration section, blah, blah, blah. And you back it up. You have to support. It's another thing. He always tells you to file these things, but he has no support. Also, arbitration has its own rules. They're not court rules. They're not evidence rules. They have their own rules. And if the contract is calling for arbitration by the creditor, I got a feeling those rules are slightly slanted to one side of the V. And by the way, arbitration is never going to come to a zero award. It's either going to give you half of this or 60-40, whereas in court, you can get totally out of it. And as I said before in my other video, go to SoloSuit's arbitration review. You can't bring the really good stuff in arbitration because the guy that's arbitrating the case won't know. He's from another state. You're in, let's say, in Michigan. So it's not simpler. It's simpler in that it gets you on the hook for a lot of money quicker. He says at 1020 to 1040, oh boy, he says in one of his videos, it makes a debt collector play fair. So in the validation video at 1020 to 1040, he says,
then here we go. Finally, last point that you probably want to put into your debt validation letter is you can close by threatening legal action. That's one of my favorites, right? Americans are litigious for good reason because that's how we make people play fair in America. You can say, hey, debt collector, if you don't do this stuff, I'm going to sue you. Okay, if you keep on contacting me, I'm going to sue you for harassment. Also, if you don't provide validation of the debt, that's a violation of the FDCPA. So I'm going to sue you for $1,000 for that. And then if you didn't provide validation within the 5 days, I'm going to sue you for that too. You could be just making all kinds of money.
Tell them you're going to sue them. Why? Because in America, we're litigious. But what it does, it makes everybody play fair. You got to be in court. Scares them. And yet, in his arbitration video, it says, get out of court. It's not fair over there. You got to be in arbitration.
You really throw them off guard by moving for arbitration. All right, so what the heck is that? What is arbitration? Arbitration is really just the simpler, so what is that? What is arbitration? Arbitration is just the simpler alternative to trial court. All right, the debt collectors are suing you in regular trial court, and they do that so they can use the rules of civil procedure against you. They want to make it as difficult as possible for you to represent yourself to get access to justice in the court. So arbitration is just a simpler alternative to court.
So he's selling you this answer and you're paying for it. Then he's saying, but go to arbitration after you spent the money doing what I'm now going to tell you to do the opposite of. Because why would he say something is a fairer, simpler place after he just got done telling you to get involved in the place that he says is not fair? And that's, what am I pointing to? I don't know. But this guy drives me crazy that he's on, people are listening to this guy. So my thought is, if arbitration's so good, why is he telling people to sue in the validation letter? Why not say, I want to arbitrate in the validation letter? Save yourself a bunch of money. Oh, wait a minute, you wouldn't be using George. Never mind. He also claims at 2.54 to 3.25, bingo.
All right. But what happens when you move for arbitration? So you submit a document telling the court, hey, I don't want this to go into trial court. I actually have a legal right to make it go into arbitration. And what that's going to do is it's going to really stop the debt collector in their tracks. They're going to be like, oh man, arbitration, we don't want to take this to arbitration because we don't want a fair battle. We don't want this to be fair. So actually what they're going to do is they're just going to probably cease and desist and stop collecting on the debt right there if you move for arbitration.
As soon as you file this motion for arbitration, the debt collector is going to go, oh, I'm scared now. And he says, quote, it stops them in their tracks and they cease and desist because they don't want a fair battle. The word arbitration is not anything to do with fair. arbitration is about following the arbitration rules that apply to the arbitration. The only fairness is the number one bedrock reason that we live in a great country. Due process. The meanest, horriblest politicians, murderers, whatever, deserve the right of due process. Why? Because we are a country that gives that. Fairness. You lose your due process rights if you arbitrate. So, do you want to arbitrate, and I guess a case could be made that that's un-American, or you have your due process rights that 300 plus years ago we fought against the British, and that beautiful document has come all the way down through the centuries, and it's still, it's beautiful. Or do you want to arbitrate and go back to only certain rules apply, whoever's in charge and paying? We got a chance when we have due process. We're due process. Arbitrate, you don't rate. So stay away from arbitration, but it is a small chip, but it's a last ditch. You know you're on the hook for 20 grand. If you go to arbitrate, you know you're gonna have to pay 10 because they cut the baby in half. Okay, but this guy's telling you it's the only way to go and it's the only way to get a fair trial. His secret tip at 754 to 829, he claims if you owe $10,000, arbitration scares the debt collector. It does not.
I should mention, this secret, it can save you thousands of dollars, right? Thousands of dollars on a debt, right? If you have like a $10,000 debt, it can help you settle the debt for much lower than even like 50% because it's going to stop the debt collectors in their tracks. So now you have the in. That is how you can save yourself thousands of dollars with this petition to arbitrate. We'll let you in on the secret. Not a lot of people know about it. It's a great tool you can use if you are being sued for a debt by a credit card company and your agreement has an arbitration clause. All right, it's a great move. We can help you out with it.
There's no evidence of this. There's no evidence of anything, George says. And if you go to arbitration, you won't use the word evidence because the evidence rules don't apply. I may have mentioned that. In Michigan, remember, you can file a motion to get out of something if you really want to go to arbitration, but don't do that unless you're sitting down with the Federal Arbitration Act and you're sitting down with the actual contract that's putting in arbitration. And the number one reason why you shouldn't do arbitration is what I said in my last video. Excuse me. You have these great rights. You can say to the debt collector, you don't own the debt. And I lay it down in all my answers on my free answers on Podcast Plus at Collection Stopper. If you don't own the debt, you can't sue me. If you take something to arbitration, you don't get to argue that. Now you just got to figure out how much you owe. So I can't believe this guy owns a business. I can't believe people pay for this guy, and I can't get enough of these videos out to help. I am making no money off this, okay? I may tomorrow, but right now, and for months, I'm not going to make money giving you this advice. And it's advice that is in writing. All I'm doing is looking at the court rules. I've worked 30 years with this wonderful Constitution and all these rules. I'm just presenting you something you can Google in a human way. Don't follow this guy, is my opinion. 2 words, and I always butcher this. I watch my own videos and I don't like how I say this. Caveat emptor. Let the buyer beware. Please, people, just watch how this guy makes his own videos and makes mistakes in his own videos. How do you do that? And then say, give me your money, I'll get you out of this, with bad advice. Because to George, all rules are really just legal mumbo jumbo. George, tell us.
It says some legal mumbo jumbo.
All right. So enough smacking George with his own words, his own documents, his own videos with my opinion. And again, this is offered for a little bit of entertainment, a lot of education. Save your butt. Save your money. You can do this yourself. Or if you do spend money on an attorney with me, and I'm not advertising myself when I say this, or with the thousands of others of good advocates out there, use my stuff. You know what? Hire another attorney, not me, and tell them, go to Parker's website and take his stuff. I'd rather that and lose you as a client. You won't get me, but you won't get this guy ruining things, because if you follow this advice, you won't save thousands. It'll cost you thousands. There's probably sound music now, outro music, trying to get me off. So I'm done off my soapbox. I hope you listen to me. I hope you're okay. You can do it yourself. You're strong, you're smart, and stay strong and smart. Thank you very much. Enjoy.